All right, wonderful to see all of you. I was insulted 3 days ago by someone who said I'm terrible with small talk. I try, but it doesn't work. So let's just jump right in with the weekly webinar. It was awful. It was a very long story. I'm going to work on it, but not on this webinar. So it's really good to see all of you. Thank you for contributing. I, at times, was a cynic, people questioning the motives of what we're striving to do. And someone joined our community. And you know, sometimes when they say, I don't mean to question you, which means, of course, they're going to be questioning you. It's like, I don't mean to be an a-hole. However, that's when it's coming. So someone wondered like why we do this, and they're in our community. They might be on the webinar. We're like, well, why do you do this? You must have an agenda or an angle. Like, what are you striving to do? Our goal is to help as many justice impacted people as possible. We are passionate about it. This started in '87 when Michael Santos went to prison and he began memorializing the journey. We strive to help as many people as possible through our free webinars, everything we give away, books we give away, podcasts. Of course, some people choose to retain our team. This is a business where we might get retained to do work that we will strive to deliver on. Some people retain us, some do not, but it doesn't change. Our goal is to help everyone traversing this really difficult system. We feel we send too many people to prison, and we want to work on that. As many of you know, Michael began articulating the First Step Act through his book, Earning Freedom, written in 2008. It took a decade for that to pass. He's now advocating for more reform. For example, he was in Atlanta last week doing a very popular podcast that you'll be able to listen to and watch soon about prison reform, work furloughs, bringing back parole, where you can prove to a probation board why you're worthy of an earlier release by way of your release plan. So we're passionate about doing the work. We give as much away as we can, but of course, some people work with our team, and we're proud to have helped tens of thousands of people over the years. We're going to transition into some of the questions we've received by way of the school community in the last week. Quickly, before we do, Scott Seek, we're going to talk a little bit about Halfway House today. Never forget, when you go to the Halfway House, there are complexities. So Scott, just share with us quickly what happened last night in the early hours.
2:38 in the morning, I get a call from the Halfway House to Mr. Seek. I'm thinking it's just a check-in, but it wasn't. Your ankle monitor is at 25%. Okay, would you please plug it in? I said, well, I'll try. She says, oh, I'm sorry. I said, I'll get it done. So I got up and proceeded to where I keep my plug in and plugged in and fell asleep on the sofa. Anyway, this happens. 25% of a battery on a 24-hour system is still 6 hours. Why they couldn't have called me at 6 o'clock in the morning or 7 o'clock in the morning is beyond me. So there are inconveniences, and as much as you really would like to spout off back at them, you can't.
That's right. So inconveniences come at that point of the journey. You've been through so much, like it's just dirt off your shoulder. But never forget, these complexities can and do happen. I'd love to ask a question here. Oh, and by the way, to the idea of, I filmed this video I'm going to put at the top of the school community, like what people I filmed it several times because I didn't like it, but I finally finished it. I'll post it soon, about what new people in our community should do. Like where should they go, including some of the resources we give away. And people frequently ask about books. I'm not saying it because Michael wrote it. I'd encourage you to read Earning Freedom. And if you don't have the money, fine, send us an email. We'll send you the book for nothing. It's part of the advocacy. The money that we raise helps support sending books to you and thousands of people in federal prison all across the country. So if you can't afford the book, send me a message. We'll send it to you. But that would probably be a good idea. In the video that I filmed, we'll walk you through all of that. I want to ask someone a question. Has anyone ever had any struggles with their pretrial services officer? Because I'm going to share a story about someone who is walking on thin ice with their pretrial services officer. Anyone here have a bad experience or just get some negative feedback from their pretrial services officer? Has it all been perfect? Anyone? All perfect? No problemos? No reprimand? No nothing? Okay. So that's great, by the way. So someone in our community met with the pretrial services officer, and some pretrial services officer will and will not ask, but this specific pretrial services officer asked, would you have any issues with drugs or alcohol? And the defendant responded, no, I do not. And this is like right after the person pled guilty, the arraignment, met with the pretrial services officer, any issues of drinking? No. Then many months later, what happened? The defendant sits for the probation interview, and he discloses in the probation interview that he has issues with drinking. And the report comes back, and the probation officer feels, the pretrial services officer, well, you can presume, how do you think the person responded? What do you think? What do you think the pretrial services officer said? Anyone?
I'll chime in.
Yes.
So I would say that the pretrial services officer went back to the probation officer and said, I asked this person many months ago if they had a problem, and they said no. And I think that would definitely be some more investigating that needed to be done.
Right. So what happened is that the pretrial services officer felt kind of duped and thought maybe the defendant was gaming the system a bit. And that if you really had a problem, you would have disclosed it. Now he's been able to overcome it in part because of good messaging. He shared the narrative with the pretrial services officer, which is something typically that might not happen because this person can't really influence your sentencing, but they can hurt you. And he essentially said, I was scared, I was nervous, I was unprepared, I didn't fully understand. And he was able to get through it. But now he has to build back that trust. The point is, even though the probation report is the gold standard, for example, for the drug program, when you're dealing with government stakeholders, you want to be consistent all the way through. And that's just a problem. Another person in our community had some frustrations. The pretrial services officer called him needy and pushy. So it's good to be like proactive and advocate, but not to the point where they think you're needy and pushy and doing more work than is necessary. I would only reach out when you need to travel, you have some health issues, you need approval for something, but I wouldn't overdo it. They don't want to do more work than they have to. Okay. Those are my thoughts, at least. Any questions or thoughts as we continue to let people into the webinar? Anything on that at all? Okay. So last week, Patty, Scott, and me were kind of going through questions that come into school. And of course, we continue to receive questions about how to get more halfway house time and home confinement time. Scott Laney, can you chime in perhaps with just what the law looks like or the percentages of halfway house time that people can receive? And then we'll talk about scenarios why people get more or less.
Yes. So the way the Bureau of Prisons runs it right now, and the conversation that you are likely to have with the case manager is, we will give you 6 months or 10% of your sentence in home confinement, but we will defer to whichever number is lower. So when I see someone who has, say, a 24-month sentence, you're looking at receiving 2.4 months of time in home confinement. Under the Second Chance Act, though, and where we've seen a lot of people have success with release plans, is documenting the journey, building a record, memorializing and showing maybe why you're worthy and what you are going to do with that additional time in home confinement. One of the things that I learned was I thought it was solely up to my case manager to decide how much time I received in home confinement. And while she did play a role in it, it's also up to the RRM, the Residential Reentry Manager. They are regional offices that oversee many halfway houses in usually a several state region. Those people are usually only judging a defendant off of their central file, which, as we all know, is mostly documents written by the prosecutor and the PO. So again, where I've seen people have success with securing more time in home confinement, more time in the halfway house, or what we call in community confinement, would be when they have a rationale, like a reason why they're worthy of that leniency, that mercy, or that more time. It can't simply be, I didn't mean to do it. I have a family. I have a job waiting for me. I have a home to live in. That's what everybody says, whether it's true for their personal matters or not. So I found that did not work very well for people. But of those in our community and those who I saw in the prison I was at, the people who received more time in home confinement or the halfway house really built a record as to why they were worthy of that.
So I appreciate you sharing that. Joseph, I want to ask you, because Joseph, you went to prison just for a year and a day, and I know you got some halfway house time. When you were there, Joseph, did you see some guys getting 3 months and 6 months in the halfway house on the same sentence? And, I want to confirm you saw some of that and maybe some observations on it.
So out of the year and a day, I got 4 months of home confinement. And there was a person who surrendered in my unit year and a day sentence. He was a doctor. He kept inundating and bothering the case manager, and he was still there when I left. And, they did give me, more halfway house time and home confinement time than expected. But everyone in my unit was bugging the case manager, and those were the people the case manager wasn't going to bat for.
So those are things that we want all of you to consider. Someone posted in school, like, I have a year and a day sentence, a recommendation, how long will my prison term be? It's like, well, what does a home cost in Los Angeles? A little or a lot? Someone posted last week, I'm going to prison for 3 years. How much halfway house time will I get? I mean, that's an impossible question to answer. It could be 0 to 12 months. Is that a big enough range for you? So we want you to consider these things as you go through your planning. It's frustrating at times when everybody is fixated on this end. Like, I will do whatever I have to do to get as much halfway house time as possible. Then they don't actually do it. Why? I have no idea. I've said it before. So if you want to get them out in the most possible, we encourage you to do the work. Is there a guarantee that it doesn't get you the results you want? Of course. Is there a chance you create a release plan, which is not a get out of jail free card, and share it with the case manager and they throw it in the trash? Yes. We have learned, however, things are changing. Scott Carper sent a message. I think he's getting his driver's license today at the halfway house, so he can't be here. But he said last week when he surrendered to the halfway house with the release plan, it helped him. It influenced his earlier release from prison. Can't guarantee it will help you, though we suggest you do the work just in case it does. Someone mentioned they didn't have a pretrial services officer. Linda didn't. It's pretty rare. I would say in most districts, you're going to have a pretrial services officer. What if the case manager doesn't give you what is recommended and gives you what they think they want? Can anyone respond to that question? I mean, if they don't give you what you wanted, you didn't get what you wanted. That doesn't mean you don't continue to prepare and document it. Does anyone have any insights on that? How you would respond if you don't get what they recommend? Anyone have anything to say? No, it's pretty apparent. You didn't get it. You didn't get it. Go ahead. Is someone, go ahead. I see you right with the blue jacket. Yes.
I mean, the thing is, no, we need to try our best, put all the efforts, put all the resources, and let the system play out the way system plays out. So that in the end, we don't have any regrets that we didn't put the right amount of efforts.
Yeah, I would agree with that. And someone asked Joseph, how often did you reach out to the case manager? I think he has addressed that before. You can reach out when you have questions, visitation, change of job. But Scott mentioned this last week too. They know if you're doing good things. They know if you're doing your job and avoiding problems and programming. They also know if you're not doing your job, if you're engaging in disciplinary infractions, they might not even write you up for. So it's not a matter of speaking to them every day, but they're witnessing and watching what you're doing, especially in smaller federal prison camps. We had someone go to Atwater many years ago where Michael finished his sentence. There was like 100 or 90 people there at the time. And this one case manager never spoke to anyone, but when someone would go in and ask for more halfway house time or something, the case manager would kind of recite what their day-to-day was like. And the prisoner was like, wow, this person never spoke to us, yet they know what we were doing. They're watching. They work there all day where you live. Probably makes sense to keep these things in mind, okay, as we go on it. Now, I want to talk about restitution in a moment. We have Sherry's attention and time. So let's go back to the 2-point reduction for a moment. There are people who are getting conflicting information about filing. Let's reiterate again when you suggest someone should file for the 2-point amendment.
I still recommend that you file November 1st because that is when the amendment is going to be ratified and it will become law. There's been no indication that there is any opposition to this becoming a law. This is going to happen. It just makes sense to do it when it's active. If you do it before, some jurisdictions might consider it, but you're also running the risk of it just getting kicked because it's not ripe yet. It's not yet a law. So the judge is going to look at it and go, well, maybe in November I would have looked at this, but it's not November yet. So I'm going to kick it back and dismiss it as not ripe. It's not ready yet to be ruled upon. And so I would still suggest November 1st. Now, I know there has been an additional update on the U.S. Sentencing Guidelines page where the retroactive portion of this is going to be bumped out until February. But that doesn't mean that you can't apply in November. You should still apply in November. Now, they may not look at the retroactivity portion of it for another, couple of months, but apply in November.
People are asking if they're cooperating. I know so many people are afraid to talk about it. And I understand that. By the way, so many people who didn't say they cooperated in prison were the ones that actually cooperated. So for those of you going to a camp, if you did, everything is going to be okay. But they're wondering if they have cooperated or post-sentencing, if they're pursuing what's called a Rule 35 post-cooperation credit.
Mhm.
We've had people in our community get 6 years and due to a Rule 35, go home, get cut to 18 months, 24 months. It's significant. There's risk involved in a Rule 35 as well,
Yes.
all of you should consider. But would it be applicable to those people as well?
Yes, absolutely. Absolutely. The main thing to keep in mind is that when you are reviewing and doing your calculations for sentencing and for sentencing hearing, and what the judge considers is based on a set of factors. One of those factors is your points, your total calculated points, which establish your guideline. When that changes, that is a material change in a factor that the judge relies on. And so when you have a material change to what they are considering, you absolutely have the right to ask for a reconsideration for that sentencing. And so that's what I want people to understand, that this is a material change. This materially changes the original sentence that the original factor the judge was relying on when they gave that sentence.
So very, very helpful. And I want to transition for a moment to, forgive me, we just got a flurry of people that want to join our community. I want to admit that. I want to transition to the moment for the value, importance of transparency and honesty, which kind of comes to how I open this interview or webinar. Like, what's the interest of you people? Nobody would do all this for free. That's right. There are some people who I know who have paid their lawyer 5 and 10 grand, totally good lawyers that I know and have referred business to. Some lawyers charge $500 to $1,000 an hour. If it takes 10 hours to create it, that's what they're going to bill. There are some people who have paid for that work and learned, I will never be eligible for this damn thing. Now you can try, but it doesn't mean. There are some cases it's going to be no chance, zeros, zilch, and people are regretting investing that money. So our suggestion is you can try to do the assessment on your own. Some people, for transparency, have worked with our team. It takes Sheree about an hour or two to go through it. It's $500 for the assessment. Following her assessment, she's going to say, you're likely or unlikely. It's better to go down on that path than spending 5 or 10 grand on a law firm to do it only to get denied. So we are encouraging all people who are eligible to apply, but at least after the assessment, you have a better idea of the likelihood. And I want you to keep that in mind. So go to your lawyer, pay big money, do it on your own, find, or invest in the assessment. But we want you to know the likelihood of this happening. And for some people, it is that they're not getting the result they want, but at least they're $500 in and they're not $10,000 in before they get the bad news. It's essential you understand all of that. Let's transition to Sherry. Any other thoughts on Gina? I see Gina. Talk to us. We're here.
Yeah. So I have a question. So
Sure.
my sentencing guideline is 14 and a half to 17 years, but my
Okay.
PSR came in at 42 months.
Okay.
My lawyer seems to be implying that we're going to get a downward departure, and it seems like I already got a huge downward departure based on my PSR. Can you explain that a little to the group?
So there's there's a lot of different factors that are being considered. And so I'm not sure 14 and a half to 17 years down to 42 months is a pretty significant jump. And that's great. So there's had to have been some mitigating circumstances involved with what was going on with your case. And I'm not familiar with your case, but I can only imagine that there were some significant mitigating factors that both the prosecuting attorney and your defense lawyer put forward to come to that 42 months. So
Let me just interject right there and just share with the group that it was my narrative and my PSR, and I have been here since the beginning. So
that's amazing then.
Yeah.
Honestly, that is what people want to hear. That's what they need to hear, because there's a personal story behind the crime. It's not just, I know the prosecutors want to take a snapshot and say, this is just an awful person who made awful decisions, awful, awful, awful. When you can sort of round that out and say, no, not awful. Here's a whole lifetime of great. It does make a huge difference. And that's a pretty significant departure. So that's amazing. And that's great. And if it gets, if you go even lower than that, that would be wonderful. Does that mean that you can't still ask for a reduction based on the law changing? No, it does not mean that. And the reason I'm saying that is Currently, the judge is considering what the law is right now, which are guideline ranges right now. And he's going to come up with a sentence based on those factors. You're still moving one of those factors downward. You're still saying, okay, I was up here based on everything, and you were going to already give me this. Now everything moves down 8 months, 9 months. So would you consider moving the original sentence you were going to give me down that 9 months because everything is shifted downward? And there's a possibility he says, yeah, because all the rest of the factors stayed the same. I was already going to give you 9 more months off. Everything shifted down 9 months. It makes sense. I'll give you that additional 9 months off. So that's the thought process, and that's the argument, because it is a material change in the original factors. So that's what I want people to try to understand, is that you are looking at it. If you were in this situation in November, your guidelines would have already shifted downward, and that would have been a consideration. And then you would have gotten probably an even lower sentence because the guidelines would have shifted. So you want to put yourself in that same position and argue that same rationale. Had this already been in place, everything would have been shifted downward. So I'm asking you now to consider shifting everything downward, because that's where we should have been.
Yeah, congratulations, Gina, on such a departure. I'll come back to you in a minute because it's relevant to what I want to transition to next, and then we'll go to restitution. I filmed a YouTube video yesterday after I dropped my son off at school, and I started this conversation in school a few days ago about someone in our community that paid a lawyer, and they're frustrated, and the government's asking for a longer prison term, in part because the defendant took so long to accept responsibility through no fault of his own. And he's just devastated and frustrated. So Scott or Patty, I'd be really grateful if you'd post that YouTube video. And in that video, I discussed the lawyer's unwillingness to get the narrative to the probation officer. And something our team discusses frequently is, what is their perspective of you? We think you're great. We don't think you should be going to prison. It's not really what we think, it's what they think of you. And I know former US attorneys who think you are trash and scum. I mean, it's just the reality of it. Let's own it and embrace it. They don't view you the way we do. And this lawyer is a former US attorney who said, I will never get anything to the government. And it's like, well, do you know the way they perceive me? Why aren't we going to try to change that narrative? And at the time, the defendant acquiesced and did not get the narrative to the probation officer. Gina, do you think, had you not gotten your narrative to your probation officer and lawyer and other government stakeholders, you would have the massive freaking recommendation that you have?
Absolutely not. Absolutely not. And kind of one of the posts that you had on school about like not having feelings, when I submitted my narrative to you guys, we hired you to help us with our narratives, and we wrote the base, the details, right? And I'm not a feeling person. And when I worked with your team, he's like, well, how did you feel? And I'm like, well, but it really drew it all out. And I mean, my lawyer was so impressed with my narrative, because she told me early on, oh, I'll write your narrative for you. And another girl from this group told me that the other night that we were talking. She said, oh, my lawyer's writing my narrative. I go, he didn't live your life.
Yeah.
You need to be involved in that. Like, I mean, I don't want some 60-year-old man writing my narrative. He wasn't there when I was 5 or 10.
And a lot of lawyers get the narrative confused with the memorandum, or they want your narrative to be like 1 or 2 pages, and they want the memorandum to be the majority of it. And a lot of that is boilerplate stuff judges have seen. The takeaway from that story, when the lawyer dismissed the narrative and release plan and essentially put them in the trash, then the report came back from the probation officer with a guideline sentence and essentially said, is this the right message? Our team, yes, we think it's the right message. You've accepted responsibility. You're focusing on victims. We think it's the right message based on what we've learned from judges. So he did what Gina did. He said, I hate to say go around my lawyer, but I'm going to assume responsibility for my own life. And I'm going to advocate, and I communicate with my probation officer. I'm going to notify my lawyer because I'm going to CC him in the message, but he sent the narrative directly to the probation officer. And I share in the YouTube video kind of what he wrote. Essentially, it was, I've spent hundreds of hours since my probation officer in an interview thinking about the bad choices that led me here. I know you're busy. I'd be so grateful if you would take a few minutes to read this narrative and consider putting the narrative in my probation report. That's a value because it comes back to the first question, how to get more halfway house and home confinement time. Your case manager in prison will have access to your probation report. You will not. You cannot surrender with it. You're not even allowed to go in with it. So if that and I know the case manager may not read it, Maybe they do. If the case manager has access to the probation report, we think it can help you if they see the narrative in there. Same with your probation officer down the road. So he did it. And it's in the report. And some people will be forced to update the narrative if major changes happen between the probation interview and sentencing. Things change in our life. It could be updated. The point is, judges have told us there's value of seeing this narrative in the PSR. We applaud our client for doing the work. And lawyer still doesn't agree. Still thinks it's a terrible idea, still believes this concept of we should give nothing to the government. These are choices you need to make. I would follow the Gina path, the Scott Laney path. Patty, other people on our team have said, I'm going to assume responsibility for my own life and do this. Any questions? I see Linda's hand up. If you want to lower your hand and unmute yourself, happy to answer your question. Linda, Joanne, this is the time to ask this question. Go ahead.
Okay, the only question I had is, Sherry, is there a template out there now that you recommend? I'm doing this for somebody that doesn't have any money.
Can we, I don't have I don't know. Go ahead.
Is there I just want to know, is there a template that to follow?
So I can answer that for Sherry because we've discussed it. Certainly there could be a template, but it doesn't, I'll let Sherry. You have to review the PSR. You have to review the plea. You have to know if they're eligible for it before they file. But Sherry, if you want to answer that, you can. Unless we lost her.
Maybe I just want to send the form to the person. That's why.
I don't, we'll find out. I don't know if there's a template. If there is,
Okay.
we'll see there. We'll locate. Joanne, your question?
Yes, if your person has not put the narrative that they wrote in their PSR, but you have it at home, can you mail it to them and can they get it into their release plan? Would that be helpful?
You're talking about your son who's already sentenced in prison?
Yeah.
Yeah, you're not going to amend the PSR to get the narrative in. It's too late. No huge deal. I would then get the narrative into the release plan and essentially
Right.
say, this was my narrative at sentencing, Your Honor. You said this to me at sentencing. I made these commitments to you. And since then, I've continued to follow through on them in prison. So I would just
Right.
simply build it. I've seen release
Yeah.
plans where it opens with the narrative. I've seen release plans where character reference letters are edited after the sentencing and they build them in there. I wouldn't overdo it. But I would get that narrative into the release plan and really focus on what he's done while he's in custody. And I know he's done a lot, but if it's not documented, he's not going to get the value from it he should.
Thank you.
Yeah, you're welcome. Great to see you. Nevin, what's your question?
Hi, Justin. Talked to a few other defendants. They've mentioned giving their character reference letters to the probation officer before the PSR, so he can see that along with the personal narrative. Do you recommend that? Do you just select a few or just do the personal narrative?
So as I articulate in our probation report course, I would not get the narrative and the letters the day of. I think it's too much information. It can be too overwhelming, too much content at one time. I like the idea of dripping it out. So whether it's before or after, that's when I would do it because they might have so many interviews that day. It's easy to forget about you. So I wouldn't overdo it. If it is before, I would get the narrative to them. I wouldn't overdo it with the letters. There's only so much content they need. So I would get them your narrative before or after. If it's after, I'd mention in the interview, don't ask permission. Like, oh, may I send you this narrative I wrote? They may say no. And then it's like, damn, don't ask, do. I've invested 100, 200 hours writing this letter. I know you're busy. I'm going to send it to you in a few days. I'd be so grateful if you would read it. Let them know how many hours you've spent in it. Don't ask permission. You're going to send it either before or after. I would do the same thing, but I wouldn't send more than 1 or 2 letters because your lawyer eventually will add your character reference letters to your sentencing memorandum. I probably wouldn't have more than 6 to 10 letters anyway, though I know some judges like Judge Gutierrez in LA, he'll read 30 letters. I've been to a sentencing hearing where he commented on like 18 of them. It's like, you got to be kidding me. Judge Wilson, my judge, he didn't want more than 6. I'll be at a sentencing hearing tomorrow in Santa Ana in front of Judge Carter. Like, I know he doesn't want more than 10 letters. I've been to enough. So I wouldn't overdo it. And I wouldn't get more than 2 to the probation officer.
Perfect. Thank you, Justin.
You're welcome. Molly, welcome to our community. I'm happy to answer your question.
Thank you. This is in reference to the woman who had the downward departure from 14 years to 40 whatever months. And she talked about the personal narrative. And whoever else chimed in said that narrative described a lifetime of good, even though you had this bad choice that led you to the courtroom. But for me personally, I haven't had a lifetime of good. I've had 20 years of substance use. So in my personal narrative, what I've been writing so far is just documenting the challenges I went through. I don't really have much good to report. Would you say that's like a problem?
No, I would
I'd
tell
like
you,
to respond.
let me respond, and then Gina, I want you to
Okay.
respond, because I'm going to tell you specifically what I heard from Judge Benita Pearson, a federal judge in Ohio. I spoke with her at an ACTO conference in June of 16, and that question came up. She said, I want authenticity. I feel like defendants lie to me. They tell me what I want to hear. And I don't like that. I need to know all of the good and all of the bad. If there has been nothing but bad, I need to know that, because that's a mitigating factor. If there's issues, substance abuse, we've seen homelessness, depression, suicide, juvenile time in juvenile halls, whatever it is, they want authenticity. They want to know about the struggles. Now, they also want to know your plan to overcome it. So if there's been rehab, if you're making improvements, if you reverted 2 steps forward, 1 step back, they need to know the vision. But never forget, the goal of the narrative is to articulate the good and bad, but why you're never going to return to another courtroom. Gina will never reoffend. We all know that, but it's of no use if the judge doesn't know that, if the probation officer doesn't know it. So we don't want you to make stuff up. If it's bad, share the bad. But if there are victims in your case, and I don't need to know the details, never forget it's about them. Because there are judges who will say, I understand you've endured trauma, you've had rehab, you've had issues, you've had problems. I get it, but there are people who have had those same issues who did not break the law and end up in my courtroom. Keep that in mind. So share the bad, be authentic, never lie, but lay out a vision to do better and why you will never return to a freaking courtroom. Then you're on the right track. Can you do that?
Yeah.
Good. Gina, what are your thoughts?
I was just going to kind of reiterate what you were saying is mine wasn't all rainbows and butterflies. And I definitely talked about my childhood trauma, which I don't talk about. So it was hard to put that on paper. So, I mean, I didn't name names. I didn't go into extensive detail. But I definitely shared my trauma. And then, like Justin just said, is that, what am I doing now to fix it? I'm 9 months sober. I haven't been sober since I was 12 years old. So, I have been taking steps for 10 months to improve my life.
That's the message. And if you can do that, Molly, you are on. It's not about how well written, how great, how well written it is. We want it to be well written. We just want it to be honest. I filmed a YouTube short video recently about an accountant who was expecting 18 months in prison. He got 57 months in prison. The lawyer and defendant tried to make it seem like his conduct was aberrational. The judge went apoplectic because he's like, aberrational, out of character. You've been a thief for more than 4 years, stealing tax returns from your clients. I'd have given you a different outcome had you been honest and authentic with me today. 57 months above the guideline range. Be freaking honest. Then after you're sentenced, because you're going to tell the judge things you're going to continue to do, then you continue to do it. Then you're going to share it with the judge in prison, with your case manager, with your probation officer. You build a sustained record over time. That's what you have to do, Molly. And if you can do that, you're going to get a different outcome. We promise you. Okay.
Great. Thank you so much.
You're welcome. Well, great to see you in our community. Robin Martinez, please ask your question. Lower your hand, unmute yourself.
Yes, I just wanted to say to Molly, my son Fletcher, when he went before the judge with his sentencing, because he had done so stellar with his probation, with his addiction and his drug test, all that, he just was stellar. And the judge really put in so much with his mental health issues and his drug addiction, and that really is what led to him having such a shorter sentence. So just do really good with your probation and do everything you're supposed to do, and it'll be okay.
Great, thank you. Yeah, I've been killing it on probation for the last 18 months. Well, pre-trial,
You just
thank you.
keep going and document it. Ricardo, if you'd like to unmute and lower your hand, what's your question?
Yeah, I just have a question. Before sentencing, what would be like the calendar before I get there to submit narratives and character references and everything that I would need before I reach sentencing? Like, do you want to have everything in like 3 months ahead?
Right, it's kind of like there's no set timeline. Every case is different. I would get the narrative to the probation officer, presuming it has the right message. If it doesn't have the right message, don't turn in anything. nothing, zero, zilch. Then your lawyer's gonna get the narrative and letters augmented to the memorandum that's typically turned in a week before sentencing. So for example, if we have someone getting sentenced next week, the memorandum's due today. So you want to make sure you have time to review it with your lawyer, and that's frustrating with a lot of people. So Nevin and others who have yet to be sentenced. Joseph did a really good job with his lawyer, Nicholas Kaiser, a really good lawyer. Joseph's like, I want to see my memorandum before it gets turned in. I want to have a chance to review it. I want to be vested in it. And he was able to really contribute to it. So there are some defendants that get the memo like 7 minutes before it's due, and it's pointless. You have no chance to review it. Not everyone's like Sharia, former prosecutor, who knows all of these nuances while going through the system. Sometimes you get it. Some people, the memorandum's turned in, you don't even know. That's really frustrating. So I can't answer the 3 months or timeline, but rather make sure you're getting this work to the probation officer and your lawyer's adding it to the memorandum. Okay.
Okay, now on my probation officer, what could I do to influence her to write a better sentencing report?
I'd prepare for the probation interview, and I'd get a narrative with the right message to the probation officer. Those are the next 2 action steps for you. If you have questions, use our free resources or speak to Scott and Patty to learn how to do it. We have courses, paid, free stuff, consulting, whatever it is. We have resources to help you, whether you have money or not, but it's going to require you to do work.
Thank you.
You're very welcome. Okay. Now, quickly, I want to transition to restitution. And unfortunately, a phone call I received from someone who's in Victorville right now, going through the detention center, I should say. Their loved one called. A defendant at sentencing made a commitment to the judge that he was going to make a restitution payment. The judge factored in that restitution payment in giving him a shorter sentence. The person then went to prison. Anyone want to guess what happened? Anyone speculate what happened?
He was not able to meet that obligation, I'm assuming.
That is correct. That is correct. And the judge was not so happy. So the judge said, I'm going to put this dude in a Con Air in transit for a little while. It's now 5 weeks. And I'm going to bring him back into my courtroom in shackles and chains and ask him, where's the dinero? Where's the money? The point is, never tell a judge something you're going to do if you are not prepared to do it. Please, money, there's no gray. You either pay the money or you don't. Now, this person's claiming things have happened. They've had expenses. I get it. Don't make a commitment to a judge if you're unable to follow through, because one click of the button, you're on transit for 6 weeks. It's a nightmare in a holding cell. The family's complaining. He has to go to the bathroom in front of 30 dudes. Yup, that's what it's like in a county jail. Shouldn't have told a judge you were going to make a payment and then you don't make the payment. Let's be honest with judges. Back to Molly's point, even if it's bad, be honest, Your Honor, I ain't got the money. I don't have it. I'd love to make a restitution payment to my victims. I don't have it. That's better than saying you have the money. And I think this person generally thought he would get the money, so that's what gets some of us into trouble to begin with. We think things are going to happen. They don't. Be honest. Great. In a few minutes, I'm going to go to Scott Seek. I want to go through some First Step Act calculations because people are curious about how long they'll actually receive. So Scott Seek, our designated FSA expert, I hope you're here. Thank God. To restitution, we continually get asked, should you make a payment? If you want to, but let me remind you, there is no guarantee it's going to lead to a shorter sentence. I know people that have given 10 million, including the penthouse. The judge still gave them 10 years in jail. Keep that in mind. Forfeiture, they may take it. Forfeiture is when there is not a victim, but the government deduces you have ill-gotten proceeds. They may come and take the boat, the car, the Rolex, or the house. Understand that when you sign a plea or get sentenced. It's tragic when Scott, Laney, Patty, or me get a phone call from someone that's like, hey, I got sentenced to a year and a day. They want me to surrender this asset. I had no idea. You're at this stage of the journey. You had no idea the feds were coming for it. That's your fault. Understand and embrace all of that. Be careful about making a restitution payment. And I would not leave yourself broke. I left myself broke by making a restitution payment. It bought me 6 months out of jail. In retrospect, 33, no wife, no kids. I would have served a few extra months in prison for that money. I wasn't required to make a payment because I came home and I needed it. So if you're going to make a restitution payment, fine. Understand the consequences, understand it might not lead to a shorter sentence, and understand that even a small payment relative to what you owe can help you, even if it's more symbolic. I had a healthcare case many years ago. I kid you not. That lawyer is Alan Eisner here in Los Angeles. Great lawyer. I know Alan. His client owed like his client owed 1.6 million in restitution. I kid you not. He made a $6,800 restitution payment. and that's nothing, but relative to what our client had and what he was making, it was significant. It's like all he had, and he got some credit from the judge for it. So it's not just what you owe relative to what you pay, it's really what you have. If you have $3 million in the bank and you make a $10,000 payment, it's going to work against you. So I'm for restitution, presuming it doesn't leave you broke. But I want you to do a cost benefit analysis. Is it worth it to give 50 or 100 or 200 grand to serve 5 months less or 6 months less with RDAP, with First Step Act credit, with good time? Some of you are thinking to yourself, I may want to keep that cash unless they require me to take it. Doesn't change when you start probation. If you have liquidity, your PO may want it. That's some financial planning you all have to do. They saw some liquidity, they wanted it. I was able to fight it off. But if you have liquid assets and no money, they be coming. Keep those things in mind as you prepare. Any questions on this subject? Anything else? Someone, any questions on the restitution or anything like that as you go through it? Yeah, I see your hand. You can ask with the blue jag. Yes, please.
Yeah, I would like to ask the difference between restitution and forfeiture, because those terms are used interchangeably and they are fairly confusing to a common person. If we can have some similarities and differences.
Yeah, we've gone through that in prior webinars quickly, as I understand it. For example, let's just say it's a drug case. You get caught smuggling drugs, and you make money from that ordeal. There might not be a victim in the case, but things that you might have purchased with the ill-gotten gains, a house, a car, a Rolex, jewelry, art, they may forfeit those gains or those assets because they were obtained illegally, but technically there's no victim. In many white-collar cases, there are actual victims who are owed money, hence restitution. And in a prior webinar, I covered both some cases like the Martin Screwley case, the Farmer Bro, where there was both restitution to victims of the fraud and forfeiture from assets that were obtained illegally. So some cases can have both, but that's the difference. Forfeiture is not really, isn't a victim there. Restitution, there is, and the government will collect aggressively on both ends. Okay. And you should, but the point is you should know these things. So if you're hiring a lawyer, people tend to be very obsessed with the prison term, and like, I get it. Nobody wants to go to prison, but as we've learned, it's the collateral consequences that accompany it. It's not just the prison term. Like, we'll go through the math on a year. We got 7 messages this week, year and a day. How long will I serve? We'll go through it. But in the end, it's not really the time in the minimum security camp that's so hard. It's like you owe money and you're on probation, and it's these collateral consequences. So you need to be aware of all of these things. Okay.
Justin, can I add to the
Yes.
forfeiture as well?
Yeah.
My case is drugs. Anything that we had on us of any value, they took as forfeiture. Watches, jewelry, and we were able to provide photos of us, like Steve wearing his Rolex 20 years ago, and they are still refusing. We got them to concede on some things, but and now it's been 10 months and I'm kind of like, we could buy a new Rolex if we have to, if that's that important to us. So your values change during this process.
And I'll tell you, forfeiture in this country, many of you know my friend Amy Nelson. If you haven't, she's in the community. She's the woman who Amazon kind of destroyed her life. They seized and took all of their money, and her husband's never been charged with a crime. It's terrible. Forfeiture and seizures in this country, even if you haven't committed a crime, are truly terrible. So you're right. Gina's right. It's just money. It's just an asset, though many people would argue oftentimes they steal, and they do. But the court tends to err on the side of the government. And if they think you've obtained it illegally, they're just going to defer to you obtain this illegally. But that's a very good example of forfeiting something. And sometimes they'll forfeit things that have value, and months later it has less value. They've seized, boats, and they treat it terribly. They've seized clients' hedge funds, and a year and a half, 2 years later, it's worth half as much, and they get less value at sentencing. The government's a bureaucracy. They're not going to treat these things well. But understand, if you have liquidity and if you have assets, you're vulnerable. And you're not going to lie. You only get into trouble for the probation interview if you lie about your financials and don't accept responsibility. People do. But you're right. It's just money. But I know it matters. Mr. Harper?
At the time of sentencing or before sentencing?
What's the question?
forfeiture, does it happen at the time of arrest or at the time of sentence? Or in
Gina just gave you an example. The time of the arrest, they had assets they took. Then in time, they can do investigations and deduce there are more assets. In the probation process, you're going to tell them all the assets that you have, and they may deduce that some of those were obtained illegally. So they're going to find things, and you're going to share everything with them, presuming you want to be compliant on pretrial. So it could be at any stage of the journey. I know people who have been violated on probation, because the probation officer deduces when the person sat for the probation interview, they didn't fully disclose their assets. I've seen that with 5 or 6 crypto cases. You didn't disclose this Bitcoin or this wallet or something that you had, and boom, they find out about it. They're back in prison. That's happened several times at Atwater, Lompoc, even Taft, where I served time, which is now closed. Don't think like, hey, the probation interview is done. It's over. I know people in prison who got a tax return. They're like, hey, this is great. I got a tax return. I'm going to sit on this for a while. I'll deposit it when I come home. I haven't been asked for financials. They deposit it. They find out, and your judgment commitment order says any tax returns, any inheritances, any lottery winnings you turn over, they don't. Just like that, you're standing for count again. It can be any stage of the journey. Okay, I'm going to come to everyone here in a moment. Brandon, good to see you. What's your question?
So I was ordered to pay restitution jointly and severally with another defendant. How do I know what's been paid by that other defendant?
Same thing happened to me, my man. I had the same thing. What I wouldn't do, so you will get notices. It took 1.5 years for me to get an update. I would only inquire if you think it's paid in full, or if you think, a sizable chunk has been, really, if it's only paid in full. There are people I know who are like constant, how much has been paid? How much is owed? And it's like, you owe $3 million. Who cares? Just keep making payments. So you will eventually get a notice from the financial litigation unit if you're off probation, or if you're on probation, from that office telling you what you owe, how much has been paid, and what the balance is. And you will learn how much your co-defendant has contributed to it. It might just take some time. I wouldn't push unless you think it's been paid in full and you no longer want to pay.
Well, I have a question on that. The co-defendant, he was ordered to pay in full immediately, and my part was over the course of
20 years. So would making payments in full reduce your paid in full, knock everything out?
That's my question.
Then in that case, if you're curious, then I would have your lawyer inquire, or I'd say my client wants to make restitution payments. I mean, that's just messaging your lawyer. It wouldn't be hard. My client has been sentenced. He understands he owes restitution. He wants to begin making payments to the court. My client would love to know the outstanding restitution payment, that outstanding balance. And at that point, they'll assess how much has come in and how much you owe if it's joint and several. Okay. Like I learned when I came home, they seized a piece of property for my co-defendant that reduced my balance $138,000. It was awesome. I'm like, hey, I made 138 grand today. I don't have to pay back. It was awesome. It took 1.5 years for them to tell me, because he made the payment they seized an asset just after he was sentenced. I had no freaking idea, but I felt like I made 138 grand that day. It was great.
Who would my attorney inquire with?
It would be with the U.S. attorney, who would then probably refer him to the financial litigation unit, or the person that's responsible for collecting money. Could be your probation officer can get that balance as well. Okay.
Thank you.
Got it. I gave copies of everything prior to my PSR, even $78 Bitcoin account. That's true. Everything's got to be disclosed. Because if you don't, then they kind of think, what else are you hiding? And it goes from good to cynical very, very quickly. Nancy, if you want to unmute yourself, your question. Nancy or Nevin, let's keep going here. And then Don, I think you had your hand was up, Don. Don.
Yeah,
when they came to check out what we had to seize, whatever possibly things they could, they went through absolutely everything in our house. We had a Corvette. I had a decent Cadillac. My husband had a brand new truck. We had motorcycles. They didn't take any of that. I had $7,000 in cash. They said, what was that from? I said it was from me, a payoff from a job, and I proved it to them. They didn't take anything but our laptops and our phones. And I'll be paying restitution probably for more than 20 years, probably for the rest of my life, because I have that much. And they take it out of my Social Security every month.
Yeah, they're going to take everything, including gold bars, according to the senator indicted in New Jersey, who's not a part of our community yet, but they do take the gold bars too from Egypt. Okay. So yes, look,
They didn't take anything from us. They took a whole bunch of stuff from my code whatever they call them, the guys that were above me. They took a lot of stuff from them, but they didn't take anything from us, and everything they took, they gave back to us.
Right. So that can happen. If you don't make payments, they can take restitution. It lasts for 20 years or until it's paid. And I know they're going to put a lien on property as well. We have someone in our community, they put a lien on the house and he's got equity and he wants money and he can't, because if he refinances, the government's going to take the refinancing proceeds, and that's the consequence of it. They put a lien on a property that I still own, and they removed the lien. That was a whole process with the US government getting the lien removed after I paid it in full. My goodness, you want a simple lien release took about 3 months. Totally nuts, people, but that's bureaucracy at its best. Eric, lower your, go ahead.
All right. Just a quick observation. As I talk with people, they often confuse forfeiture with restitution, and they are very different. If money is taken from you at the beginning of the case, that does not necessarily go towards your restitution at all. So it's possible for the government to do a double dip. In a white collar crime, if they sees 500,000 out of your account as ill-gotten gains, there's a process internally where the government can look to applying those funds to the victims, but it's not automatic. It's possible to have the government take your money and have that as a forfeiture amount that goes to the Justice Department, and you still will owe that 500,000 as part of your restitution.
That's right. Now, well, it's essential for restitution and fines that the numbers are correct. Someone in our community who is getting sentenced in a couple of weeks the probation officer made a report on the financials. I won't get into all the details, but essentially he owns a percentage of the home. The probation officer wrote as if he owns 100% of the home. And if the judge were to see like, wow, he owns 100% of this very expensive home, it would make it easier to justify the fine the Department of Justice is asking for. Once you remove this percentage, I think a fine is much less likely, or not to the degree that government wants. So that's why the PSR should be correct. The judge usually opens up the sentencing by confirming the defendant has read the PSR. Some lawyers will object. They won't even make changes or corrections. They wait to do it at sentencing. Fine, some don't do it at all, but you need to be vested in this process. A lot of lawyers will say, don't worry about the money. My goal is to get you the shortest possible prison sentence. I would do it differently. You want the shortest sentence, but it's also essential the numbers are correct. The restitution number is correct, because that follows you long after prison. Just don't acquiesce, as a lot of people do. We have a number of people who go to sentencing, restitution isn't resolved. They don't deal with it until they come home from prison. And by the way, if you do that and they still want you to make payments in prison, I would make them, even if technically you're not required to. Okay. Let's see. Nevin, did you have any other thoughts before I go on to the next subject?
Yeah, just a quick question. Is there an opportune time to advocate for a particular payment plan for restitution? Like, I want 10% of gross, 10% of net, or something like that.
So a couple things. One mistake my wonderful lawyers made was not asking the Department of Justice to apply interest, and they did. They charged 1.66%, and my number was about 435,000, which is a lot of money. I paid it in full, but think about that, 1.66%. It took me 11 years to pay it off. Had they asked Judge Wilson not to apply it, I think Judge Wilson would have said yes. So once you get restitution, I would have your lawyers ask the court not to apply interest on it.
So is that done at sentencing or the restitution hearing, or
at my sentencing hearing? Judge Wilson ordered restitution. It was like 535, and then they took some proceeds from my defendant, so maybe it was down to like 420. And he said interest to be at 1.66%. And my lawyers accepted it. And I wish they would have said, Your Honor, based on my client's financial situation, he just gave the last $100,000 to his name to the court. He got that $100,000 from liquidating his retirement account, which is going to come with a 10% fee, plus the money he took out is going to be added on to income. So now he's going to have a tax obligation, but he's done this to help make his victims whole. Would you please? I mean, I'm not a lawyer, but it wouldn't have been hard to say that.
Yeah. So, but you do that at sentencing?
Yes. Yes. Okay. Yes. Thank you. Now, keep in mind, to the 10%, that, like in my case, it was 10% or $500 a month. Part of that is window dressing, probably to appease victims, because when you come home, if you're broke and have no money, they're not going to take $500 a month, right? So it's kind of like the judge puts that on there. But when you come home, your probation officer is going to go through your financials and come up with a payment plan for you. At first, for me, it was $100 a month. And then when things got better, it jumped up quickly, but it really never got to $500 a month, believe it or not. It never did. But that's what Judge Wilson said in my judgment and commitment order. They say that. It's really up to probation down the road. Don't freak out if you hear that.
Got it. Thanks, Justin.
Yeah, you're very welcome. Wow, a lot of talky here. Any other questions? Okay, let me just knock out a few other things. Hunter left a great comment in school. I thought it was so funny about he's from Arkansas and his name is Hunter, implying apparently that means he's into guns. If your name is Hunter from Arkansas. So the idea of guns came up. I think Steve covered this. Get rid of the guns now, right? Just get rid of them now. And we'd encourage you to send a message to your lawyer that says, I got rid of these guns this day at this shop. It was done legally, and just have a record of it. But there are some people who get ripped apart by their probation officer when they visit the home, only to learn guns are still there. And some people are like, well, I thought I'm not convicted till I'm sentenced. And, just get rid of the freaking guns, people, legally. Get rid of them. There's very little upside. And I know it. Yes, someone said if it was a bow, if I'm not mistaken. Yeah, the bow might be fine. That's fine. I would have no guns. I would have no weapons. Anything where they can construe that you have it there, that's your choice. But I'm sure some things like a bow might be allowed. I'm talking about the handguns, the rifles. I'm not a gun guy, never was. Just get rid of them. Don Carper, did you want to, your hand was up earlier. Did you have something to say?
Well, when you're talking about forfeiture, they seized some stuff of Scott's, and even in the plea agreement, they agreed that he would, in fact, give it up. And about 2 years later, we get a letter and say, if we want the material, we can come get it. And I did. So,
Yeah, I did.
again, one of the items or some of the items were electronic stuff, and after a couple of years, the value is pretty substantially reduced. So I don't know how worth it is. I actually went because I wanted to complain to one of the Homeland Security people about the lack of their investigation, but that accomplished about as much as you would expect it would.
Yeah, no kidding. No kidding. So, well, thank you for sharing that. Someone in our community.
So at least I say to Gina, you're earlier in the process. You may still get a letter getting some of that stuff back.
Yeah, and it's the same Homeland Security people that Scott dealt with. So
same people, same place.
Yeah. Someone, I want to knock out the last, we're at 11 o'clock. There was a couple other questions I didn't answer. Someone in our community asked why they went to the halfway house and they were denied a sales job. And now they, the person in the halfway house, they want him to do, they're requiring him to, I'll tell you why they didn't approve the job in a moment, but he's required every day to come back with at least 10 employment applications. And it's kind of sucks. So he has a radius where they've given him permission to work because he doesn't have his driver's license back yet. I see Scott Carper here. Scott, I hope you got your ID back today or something like that. So he doesn't have a car and he does have insurance. And so they're requiring him in like a certain radius where he can walk or Uber to look for employment, jobs that don't necessarily appeal to him. And his case manager said, every day that you come back, I need to see 10 applications that you filled out for work. If not, I'm going to violate you. And, it's tough. The reason his job wasn't approved, it was a terrible letter that didn't fully articulate what his obligations would be. The person who offered the job, it wasn't a very good phone call, because the halfway house is going to speak with your employer, right? They're going to confirm, at least they should, or they're supposed to. And the person who offered him the job didn't fully understand what the employer's responsibilities would be. Can anyone here articulate what some of the employer's responsibilities are if you work for them in the halfway house? Can anyone share with us like what that employer is required to do? Anyone? Anyone know? If you want to get your job approved in the halfway house and not work at KFC, these are things you need to work through. So what is an employer's responsibility, presuming you want to get your job approved? Anyone?
They need to understand that you're a felon, that your probation officer or staff from the halfway house is going to contact them on a regular basis, and they need to respond to those people. They can show up at your job at any time to make sure you're there. Maybe have a chat with your employer. Those are what I can think of right now off the bat.
That's basically the best answer we've ever heard. And it's the right answer. The halfway house speaks with the employer who's sort of like, yeah, I know he went to prison. What do I have to do? You're going to be calling me and showing up, like didn't fully understand that. And I was like, any hesitancy, job denied. So make sure your employer knows they're going to be calling and showing up. And if the employer doesn't call back quick enough, you know what they do? They revoke the job. Okay. It's really that simple. So this job wasn't lined up because the person didn't prepare properly. Don't presume they're going to approve a sales job. They didn't. And now he has to come back every day by 5 o'clock with 10 employment applications from places he doesn't want to work. And he's saying the good old thing that everyone says, I wish I was back in the camp. You need to overcome all of these things, or the time in our community, you're not going to get the value you should. It's truly that simple.
Hey, Justin, have you seen halfway houses approve a remote W-2 job?
Yes. I think Scott Laney got approved for that with us. I mean, yeah, sure. But I'm not saying this because Scott's on our team, but he's on our team for a reason. He did like everything we suggest you do. He mitigated a release plan. He wrote a blog every day like Scott Carper. I mean, it was no accident that in Idaho, in the halfway house, they approved his working for us. The day he was done, they allowed him to come to California to work with Michael and me and our team. Like none of it was by accident. It was engineered before he went to prison. So the answer is yes. Look at Scott Laney as an example. He just did everything that we suggest. But even if they didn't approve some of it, it's still good that he did the work because it's influenced his whole life and the way people perceive him. But to his credit, he did it every freaking day and it's documented. All you have to do is go to his website and read it. It's not made up. So yes, be like Scott, do the work. Any other questions here? Angie, I see you. Angie, yes?
At what point do you know that your job is approved? Like, when do you hear about that back?
It's actually funny you asked that. There are sometimes the job will be approved and they won't even tell you. Some of these people in the halfway house, I'm glad these webinars aren't on YouTube anymore. Okay, because they're not great. Okay, let's leave it at that. There are times that it's approved, they won't even tell you. You got to go ask them. So in my case, it was approved when my probation officer approved it. So they approved it and then they speak with my probation officer, and he approved the job. So once it was approved, it took me about, I don't know, I was out working the next day, but they spoke with my employer like several times to confirm my role and what I would be doing. It was a little more complex for me because I returned to a real estate office where I sold real estate before I went to prison at Sotheby's, and they wanted to confirm, even though I still had an active real estate license, that I would not be doing any selling. So they had to have several calls with the broker of the firm to confirm. That took probably a week or so from start to finish. But once I was approved, I start work the next day.
Okay, because my boyfriend is currently still serving, but it's closer getting to the end. So that's why I just wanted to know approximately like when he would hear back, but that answers that question.
Yeah, he will not hear till he goes to the halfway house, but I would encourage him to show up to the halfway house with an employment letter, 1 or 2 to 3 at least. And per what Scott Carper said last week, I'd have him surrender to the halfway house with his release plan and give it to them. We have a release plan book on Amazon you can buy, or just go through our free resources. But if your boyfriend wants to get the job approved and get to liberty more quickly, I would create that release plan in prison and surrender with it.
Oh, he created everything already.
Perfect.
We're just
good.
Yeah, we're
Then
just waiting to hear. Sorry, we're just
No,
waiting.
you're fine. You're okay. Just forgive me for jumping in. You'll get the letters approved once he gets to the halfway house. Now there could be a lockdown for a week. I think Scott Carper said last week he was locked down. Scott, are you on here? Are you still locked down? Scott, you there? Scott, if you want to unmute yourself.
Yeah, no, I actually just got off lockdown this morning. I was just at the DMV. That's why I came late. But actually, in response to my release plan, they're going to be letting me out on the 15th. So that's less than a month that I'll be at the halfway house. So I had a big day today.
Yeah, congratulations on getting out. I know you appreciate little things like going to the DMV and things like that you never really appreciated before.
Yeah, it was traumatic. Wow, it was different.
All right, good. So there were 10 questions I sent out this morning I wanted to address. Oh, one more, Scott Seek. Let's wrap up with you, calculating sentence lengths under the First Step Act. So Scott Seek, we had someone in our community said they got 2 years in federal prison. Scott, are you there? Where are you? Yeah, there you are. Someone got 2 years. What potentially could that look like for no RDAP or anything like that? Just a 24-month sentence. Let's go through some of that math.
Simple calculation on that part. You just take the 24 months, multiply it by 0.85, meaning 15% off. It's going to come up with, what is it, 20 point some months? I'm not doing it with a calculator. What you have to realize when you're doing the calculation for FSA now is you're going to earn about 2 months in the first 6 months. That's 10 days per month for basically the first 6 months. Then somewhere after your second assessment, which now seems to be around starting month 7, you're going to earn 15. So when it's all said and done, you're going to earn probably a total of 5 months, maybe 6 or 7 months of FSA, depending on the calendar. And what I mean by calendar is there's a calendar moving forward and there's a calendar moving backwards. So as you progress, you're earning more time. That more time brings your PRD or your release date closer and closer. The problem that's happening now for a lot of guys that are eligible for halfway house is that the BOP is not actually calculating the projected release date in anticipation of the clock moving backwards as you move forward. And this causes a real hardship. Guys that need the time in the halfway house to get acclimated, to get a job, earn some money so they can have an apartment, whatever it is they need, are losing halfway house time that they were entitled to begin with. And it's going to happen probably for the next 6 months to a year until the BOP corrects, I won't say corrects, adds another date to their calculation. Calculation right now is a stagnant calculation. It's very easy to determine. But your PRD date, because the only date that they're showing is your entry date minus 15%. And then as each month goes by, the additional 10 or 15 days off of that date. The problem is that date changes. It comes forward. And Scott Carper, this is for you. If the 15th of October is your last day, guess what? You're probably out on the 13th, Friday. They're probably going to cut your ban like me on Friday the 13th. Yay. So keep that in mind. So I think by January 1, we're going to see a corrective measure with FSA. And guys, I'm more than happy. Anybody who wants a little, the White Collar has a calculator on the website. I'm more than happy to do another manual calculation for people if they're looking at it. The confusion also comes up with RDAP. And I know Justin wasn't including RDAP in this conversation about 24 months. But RDAP and FSA are simultaneously earned. So if you're eligible for RDAP and you're doing RDAP, and I'll just use this as an example, let's say that you're entitled to the full, was it 30 months, Scott? 30 months gets the 12 months.
24 to 30 months with RDAP, you get 6 months off. 31 to 36, 9 months, and 37 months or more, you can get a full year.
Okay, so more than 37, you're going to earn the 12 months. But that 12-month off you're also earning FSA days in those 12 months. So it's interesting when you look at it that you could earn basically 15 days a month after the first 6 months simultaneously. And so the clock moves up very quickly.
And coming back to that, which is why, like on a 37-month sentence with RDAP, you'd probably do 10 months because you have to be there at least 9 months to complete the 500-hour program. Okay, now, so let's go back to this math for a moment. So 24-month sentence, good time, it takes it down to just over 20 months, call it 20 months for easy math. You're there for the first 6 months, you get 2 months off. Now we're down to 18 months. So Scott, let's just reverse engineer this math, 24 to 20, and then we'll get into the potential halfway house range.
The easiest way I do it verbally is you're down to 20 months, okay? That's without FSA. You're gonna be there about 12 months. In 12 months, you're gonna earn 5 months of FSA. 2 months in the first 6 months and 3 months in the next 6 months. That's a total of 5 months. So take 5 months off of 20 and you're down to 15 and you've been in for 12. So you only have 3 months left. Scrap 1 month, maybe 2, depending on what day of the month you came in. So you might pick up an extra 15, maybe 30 days. So 15 might be as much, you might be in as much, 15 minus another, maybe a month, maybe 14 months. Best.
Right, and it could be, of course, it will turn out to be less because you're going to get halfway house time.
Yes.
And so this is where it becomes a little, you know, if you're not in as long, you're not going to get as much credit. So the point is, you just hear all the mechanisms for an earlier release with Good Time and First Step Act. RDAP really changes things. RDAP doesn't help as much if you have 24 or 30 months, because while you're getting FSA credit, you have to be there at least 9 months to get it. Now, there are some people, Scott discussed this last week with someone in our community who had a 24-month sentence who was encouraged not to do RDAP. And because of that, he ended up getting so much more halfway house time. He served less time in prison because of the halfway house, less than had he done RDAP, because he would have had to be there at least 9 months. These are just, so we want you to have an idea. I think what's most important about the computation is the first 6 months, you're going to get 2 months, and then the next 6, most likely 3, 5 in the first year.
Correct. One last thing, which doesn't really affect everybody on this site, but there are a couple people. I see Lynn there with her son and others. People who've been down for a long time. Okay, this gets confusing for them because the BOP screwed up the FSA calculations in 2022 to begin with. They weren't calculating manually correctly for people that were actually in prison in 2018, 19. So that has since been corrected. The question comes up with these people is, when did they meet the minimum or low recidivism rate? Okay. And this is a difficult question to ask or answer for somebody on the outside. And really, the case manager is probably the only one. The way the FSA works is that you are earning the extra 5 days when you have been a low or lower for 2 consecutive risk assessments. Now, those of us that come in the very beginning, we basically have 2 assessments in the first year. However, if you've been in longer than a year, you're basically only going to have a risk assessment every year until you start getting down to the last year or so of your sentence. And that might be multiple times in the last year, meaning every 3 months. So there's just keep in mind that people that have been down longer or who are going to be in longer, now people that are down longer now just have different calculations than those of you going in. It's kind of cut and dry if you're going in now.
Yeah, that's very helpful, Scott. Thank you as always for doing that. As we wrap up the webinar, are there any, I see Tammy, if you want to lower your hand. Any other questions here?
Okay, quick question. My daughter just moved into the RDAP unit, and she said she thinks she's going to start in December. That's when the next class starts up. I've been working with you guys and Sherry on that 2-point reduction. So now I'm wondering, like, is those 500 hours, is that like a commitment, or if this reduction come through, you know, is she stuck in RDAP? Or would she, you know, be able to take the 2-point reduction and get out of RDAP to be released?
If I may, Justin.
Yeah.
Completely scrap that whole concept of 500 hours. It's dead. It got buried in 2022 when Colette Peters came out with the newest updated policy statement for FSA credits. There is no such thing as 500 hours. Okay. It's simply 10 days or 15 days based on whether you are a minimum or a low. And quite frankly, even people that are above lows are still earning FSA. It just cannot be applied to early release. Okay. They may get more phone privileges or other privileges. So scrap the 500-hour business. If somebody goes into RDAP, they have a 9-month commitment or longer, because not everybody completes in 9 months. And during that 9-month period, depending on when it falls in your risk assessment period, you're either going to earn 90 days or some portion thereof or more. So keep that in mind.
Very helpful. Thank you. Thank you. Are there any other questions? And I think it's helpful with so many questions coming into school, kind of covering these. We've covered a lot today. Sherry, thank you for joining us again. Are there any other questions as we wrap up? Joanne, is that your hand there? Or we already answered that? Is that you, Joanne?
Yeah. Yeah. I don't understand what Scott just said. Are you saying the program is 9 months, no matter how many hours you put in? I don't understand what you just said about that.
The two distinct things. RDAP is a 9-month program.
Yeah.
Okay. You're going to either earn 6 months off or 12 months off, depending on the length of your sentence.
Or
That's
9.
right. Or yeah, for the 9 months that you're committed to RDAP.
Right.
The 500-hour was a terminology used in the incipient stages of First Step Act. Okay. It's gone. Has no relevance at all anymore. Okay. So it's very simple. You are earning FSA credits as long as you're doing what your case manager tells you to do. Programs, okay, or working, anything that's FSA qualified. The fact is everybody's understaffed everywhere. So basically, if you're not causing any problems and you're just breathing in the camp, you're earning FSA credits.
Okay.
Yeah.
Thank you.
Okay. Is that these Thursdays seem to come quickly. It feels like we just did it last week, but here we are again. Okay, great. Grateful for that all of you are here. I continue to admit people in, but the webinar is wrapping up. I don't know how that works. Thank you for joining the 17 seconds of the webinar. Okay, I will see all of you in the school community. I will put up the replay today or tomorrow along with any resources that were mentioned. Thank you all for being here. Gina, as always, thank you so much for your valuable contribution. Scott, all the Scotts on this call and everyone who's here. Thank you, and we will see you next Thursday and inside of school.
Thanks, everybody.
All right, guys. Bye-bye.
Thank you.